Good morning and welcome to the Mkumba Eye. As usual, we are bringing you exclusive interviews, and today I have one of the proud products of Mkumba University. He is the council, and yeah, I will let him introduce himself and we shall dive into why we are here today. Good morning.
Good morning.
Yeah, could you say hello to our viewers?
Hello to our viewers for watching us on this Kumba Eye. My name is Nkamweske Nixon.
Yeah.
I'm a proud alumni of this mighty university. I'm a lawyer and I'm a mediator, mediation practitioner, and I'm an arbitration practitioner, and more so I'm a mental facilitation officer.
Okay.
So thank you for hosting me on this mighty channel.
Yeah. Today we are going to be talking about something that is trending in the judiciary system, and this is ADR. So would you tell the viewers what is ADR and what is it all about?
Thank you so much for that wonderful question, my sister Lydia. ADR, it's alternative dispute resolution. Generally, these are methods of solving disputes, short litigation. Before going to courts of the law, disputes are solved outside the courts. So it is methods of solving disputes before going to courts of the law.
Yeah.
That's what ADR is.
So in a common man's language, it means solving disputes before you go to court.
Yes, please.
And if it doesn't work out, then you can do what? You can go to court.
Yes, please.
So why do you feel like ADR is the best technique for solving problems? Because people are now used to court, they might not be able to trust it.
Oh, thank you so much. Yes. Before going to that question, there are methods. ADR itself, it's having the mechanisms in it. Basically, generally, there are four. We have negotiations, we have arbitration, we have mediation, and we have what we call conciliation. And in each and every mechanism, we have the way of doing stuff, of doing things. And for example, let me talk about mediation. Under mediation, this is where a neutral third party facilitates the negotiations between the parties in a dispute. That's what mediation. And we are having arbitration. Arbitration, this is where a third neutral party listens to the parties in a dispute and they make a binding decision.
He's not supposed to be on any of the sides.
Yes, he's supposed to be neutral. Why is this person supposed to be neutral? It means that you're not supporting any side, or we need this thing to be fair. So when someone is in a relationship or in a relationship with someone, it means that this the decision will not be fair. It means he will be supporting some side. So we want this party to be what? To be neutral in order for us to have a fair decision altogether, to have a just decision. So basically that party must be a neutral. So that's what we call arbitration. A neutral party listening to these parties and you're using the language of the law, but let's go in that way. Someone who is complaining and someone who is
defending themselves against the complaint.
So this party should be neutral and it should be the third party and just listens to the matters between them and makes a binding decision. You see the difference between mediation and what? And arbitration. In arbitration, this party makes decision, whereas in mediation, the party only facilitates. Are we together? That's the difference between mediation and what? And arbitration. Now let me talk about negotiation. Negotiation, this is where the parties in a dispute sit and decides or negotiates without a third party. For example, we have the background in our homes. A father and a mother, they are in a dispute, they sit down in their house and they negotiate instead of bringing some other party into their matter. Are we together? You're in the same area, you're having disputes in the land, you come and sit, you negotiate, minus having a third party. Then conciliation. Conciliation is like mediation. They're actually 90% the same.
Yeah.
But the only difference that we're having in conciliation is that in conciliation, this party sometimes proposes some solutions. For example, in mediation we just facilitate, but here we propose some solution.
Now
For example, you can say, why don't we go? Yes, the third party sometimes
to give
sometimes
ideas.
gives an idea. But why don't you do this thing in this manner? Are we together? So it means that in some instances, this person can do what? Can propose some solutions of which we are not having what in mediation. In mediation, we just facilitate. Are we together? That's the difference. There are 4 mechanisms of ADR. Okay.
Thank you. So back to the question. After like explaining all that, what reason can you give to someone to convince them that ADR is best for them to solve their problems instead of going to court?
Thank you so much,
Yeah.
Madam Moderator. ADR as itself, it is having very many importances and advantages, I can say. For example, ADR saves time. It saves time. For example, in courts of the law, we are having very many cases that have spent many years. So this one comes because it is done outside of courts. For example, initially, usually we do, like in mediation, 4 sessions are enough.
Yes.
Are we together? So you see 4 sessions, and depending on how parties have agreed. For example, you can organize 4 sessions depending on the convenient time these parties are having. So you find that the matter has been solved very fast compared to how this party would have been solved while in courts of the law. Because in courts of the law we have very many cases, what we call case backlog. Are we together? So this ADR or ADR mechanisms reduces case backlogs in court. We are having many files in courts, many files, and you find someone puts or sues a party in court, but he spends more than 40 years without justice, and the matter has not been heard. Are we together? Yes. But in ADR, we just solve it outside, and it takes short time. Are we together? So you see, it's very important. We get a quick justice in ADR. Secondly, it saves money. So in courts, we have to pay legal fees.
Don't you pay the third party? Who is
yes. For example, we have the laws that govern ADR. Yes. For example, the Judicature Mediation Rules of 2013. Yes. That one is one of the laws that governs the procedures in in ADR and basically mediation. So what does it mean? You appoint a third party. Are we together? For example, the parties sit and agree on the mediator that is supposed to facilitate their dispute.
Does that mediator have to be a lawyer?
No. For example, we are having trainings. We are having trainings. For starters, people always know that a mediator is supposed to be a lawyer. But we have got institutions that have come here to do what? To train people to do what? To practice ADR. For example, AMUSU, Arbitration and Mediation Society of Uganda. Myself, I got a certificate in AMUSU, from AMUSU, Arbitration and Mediation Society of Uganda, in collaboration with Makerere University Business School. I also got the certificate in mediation.
And it is recognized by the judiciary of Uganda.
Yes, it is recognized by judiciary. Even the stakeholders in the law, for example, our president has always been in support of this. We have seen the Chief Justice. He has also brought an idea that you have to go for mediation, and that one has been there, even in the laws of Uganda, in the Constitution, altogether, and even in civil procedures rules.
But then won't that put down courts? Won't that totally remove courts and people now just go to solve their problems through those people who can reconcile you through the ADR?
No, please. ADR has not initially removed courts of the law. Are we together? But courts, people still look at courts as if for them they don't like peace at all, because they need work. But courts of law need peace. Actually, in ADR we call ourselves ambassadors of peace. What does it mean? It has not initially removed your right to sue someone in what? In courts in order to get justice.
Yeah.
But at least you first do what? You first pass through the procedure. Before you rush to court, first negotiate outside of court. For example, in courts, while doing procedures, we have what we call scheduling conferences. Altogether, lawyers are supposed to meet, they negotiate about issues altogether. And those that are supposed to go for mediation,